Hello again, everyone, and thanks for joining us as we tape another segment of Chicago Lawyer Magazine's Inside Out, where we explore various aspects of the law with our husband and wife team. They have a unique perspective. David Susler, he has the inside view, which he should have because he's Associate General Counsel for National Material LP. The outside view comes from Christina Martini, who's a partner at DLA Piper. I'm your host, Andy Shaw, President and CEO of the Better Government Association and formerly political reporter at ABC7 here in Chicago. Today we're going to discuss the all-important topic of communication, which is critical in legal matters and virtually everywhere else. So let me ask you, as you negotiate the communication challenges of a relationship between the in-house counsel and whoever he or she has retained, what makes it work well, at least Tina, from your standpoint? You're the one that has to basically be accountable to whoever's hired you, the inside person.
Well, I think what makes it work well is for the outside counsel, somebody who is situated like I would be, to really understand the client, to understand what they need, what they want, and what they don't want. I think a good communication pattern or system, I guess for lack of a better way of putting it, is really established. It's a very personal thing. There's some clients that I have that like to communicate early, communicate often. I talk to them or communicate with them in some shape or form every day. And then I've got some clients who really prefer to just be sort of informed about the highlights of a particular matter or a particular engagement. But I think being transparent, really understanding the client, understanding the importance of a particular engagement, and just using good judgment and using your gut when it comes to these sorts of things. I think using what you see as good communication with personal relationships is often a good guide for good communication with a client.
And David, do you have to establish these parameters at the get-go? Do you have to say, I want to hear from you every day, or I don't want to hear from you that often? I mean, is it important to do that, or is it done more intuitively as you move along?
Yes.
Yes to both?
It's yes to both. It is a very good idea when dealing with outside counsel to establish early on what your preferences are, and it's going to change depending on what the purpose of the retention is. But yet, and everybody has their own style. I want email. I want phone call. I want, you'll rarely hear, I want a 50-page memo. But you do need to make that clear. And then, if it's a short-term project or a long-term engagement, that may change and evolve over time. I also want to add, within the in-house context, the same thing holds in direct answer to your question and going back to what Tina was talking about in what works in communication and the style is, we have the in-house lawyer and the outside lawyer need to establish their patterns of communication, but also the in-house lawyer serving the business client in-house. We also need to establish rapport and communication styles. And that, that's going to vary by company and person, but ultimately you have to have the same conversations. We have businesses, plants all around the country, so you're not going to have face-to-face, but within my office, I get up out of my chair and walk down the hall and interact personally, because the interpersonal face-to-face communication, I think, ultimately always works better. And as long as if you establish that and look somebody in the eye once in a while, it enhances the value and efficacy of the written communication.
Does the communication expectation and challenge change as the case moves along and you maybe get into a little more of the intense area? Either you go to trial or you're preparing for trial or you talk about settling cases. Do those expectations, do the requirements of communication change as you get deeper into the matter?
Sure. I think there's a natural ebb and flow throughout the course of a matter. You may have some frequent communication at the outset as you're establishing the project. There may be a lull as you are building up and going through the process, but then as it's reaching a conclusion, whether it's a deal and you're approaching the closing date, or it's litigation and you're approaching a heavy-duty deposition period or the trial, communication is probably going to speed up in frequency.
So you want to add
Oh,
anything?
well, no, I mean, I absolutely agree because, and I think it's directly related. or at least somewhat related, in most cases, to the level of importance of a matter. So litigation, obviously, you've got people who are arguing about something and are disagreeing about something. And when you've got issues like, when you're either talking about settlement or when you're talking about going to trial, there's obviously going to be increased intensity. The same thing with a deal. If you're either, trying to buy something or sell something, it's the same sort of thing. There's usually, when you've got something but that's of high stakes or high importance to the company, I think that you often see an uptick in the level of communication and in sort of the tenor of the communication that results.
And then, there are natural lulls in the process of different matters when, there may be nothing happening for days or weeks or sometimes months at a time. So you don't have to talk every day or even once a week. My preference is that my outside counsel not just disappear during those times. I don't want to not hear from my attorney for 3 months and because I'm going to wonder what's going on. So, I always suggest at least shoot me an email once a month, once every other week, just say, we're still here, nothing's happening, I don't expect anything to happen for another 3 weeks, but I'll keep you posted.
Well, you just cited a no-no, which would be sort of going radio silent,
Yeah.
as you put it, but what are a couple of other no-nos in the communication realm that are counterindicated for a good relationship? What shouldn't you be doing, or I guess the no-nos are things you shouldn't do?
Well, as we talked about before, you want to set out the nature and parameters of the communication. So doing something other, if I say, look, all I want is a phone call and you're mailing me long treatises, that's a no-no. Corresponding with the radio silence is that my only communication is a bill and I had no idea you were even working. That's probably not a good idea.
Or adding people to a file, especially if they're going to have a significant role, and not communicating
Yes.
that you're adding people to the file, to the client before they see the bill.
Right.
And so I guess the last one then is, how do you maintain a balance so you're properly responsive to the other side, but not micromanaging every move and really over-pestering, as it were?
That's an interesting question. The answer is, as a person who leads teams, who does substantive work on client matters, but also leads teams, I do try to strike that delicate balance with respect to the team that I'm working with, and to also make sure that we're managing the client's expectations. I think it really is important to trust the people that you work with. So I try not to micromanage by getting the best qualified team for whatever substantive matter we're working on, and also conveying to the client that my time that's being spent on the file is true value added to the particular engagement. And I will sometimes just play a role for a particular engagement where I don't bill my time, but where I'm helping to do the sort of behind the scenes work for the client, so that they don't feel like they need to be micromanaging or even to be thinking about how is this work being managed. I help them do that, and that's just part of what I deliver to a client.
Right. I never want to pester my outside counsel. If you've got the trust and the communication established, it shouldn't have to come to that. And I try to be mindful that, first of all, they're busy too, and I want them to give me the best possible service. If I'm pestering them, they're just going to get, we're all human beings, and they're going to get annoyed, and it could, whether intentionally or not, impact the representation, which I don't want to trigger. But on the other hand, as the client, it's my matter. It's my company. I am the client. If I don't feel that my attorney is communicating properly with me, I'm going to be contacting them. It's my job to manage it. So I don't think about the micromanagement part. It's not a concern from my end with my outside counsel. But if we have the communication flowing, it's not an issue.
Well, we kept it flowing in this segment, did we not?
Yes.
David Susler from the inside, Tina Martini from the outside. Thank you all for joining us as we tape another segment of Chicago Lawyer Magazine's Inside Out. I'm Andy Shaw, and we'll be back next month with another legal issue.